Right before I left for London, I did somewhat detailed examination of the issue of affirmative action and the Supreme Court's very important affirmative action case. But I only alluded to or gave a little bit of short shrift to the issue of religious liberty. And there were two very interesting religious liberty cases that the court decided. The first one was a very a very clean 9-0 decision. A postal worker who wanted a religious exemption from having to work on Sunday. The post office basically goes, no, that's rules are rules. If we need you to come in on Sunday. The guy goes, I can't come in on Sunday for religious reasons. And the court basically sided with the postal worker and said, look, if somebody has a problem grounded in conscience with not being able to perform a certain task, the company has a duty to try to accommodate this guy, to oblige him, to figure out a way. The guy wasn't saying he wanted to work one day less a week. He was happy to work on another day. He just said, I can't do it on Sunday. And the court basically said, unless this places a kind of strong burden on the company, they somehow can't function. They're a company that only does business on Sundays, in which case, why is this guy working for that kind of a company? Unless the company has some strong reason for doing it, they cannot, just because rules are rules, we feel like asking him to work. The court 9-0 basically sided with the postal guy. Now, the other case, much more controversial, had to do with an LGBTQ demand. An LGBTQ demand that a woman, Laurie Smith, create a website. She's a web designer promoting LGBTQ themes. And the case went to the Supreme Court, and the Supreme Court sided with Laurie Smith and said, look, you can't force people against their will to do things that go against their conscience. And so if this is a woman who has a Christian objection to building LGBTQ websites, the LGBTQ couple needs to go, the LGBTQ person who wants the website needs to go elsewhere. Now, once the case was decided, the New Republic did a story basically saying that the case was bogus. And it's bogus. Why? Because the man who supposedly sent the original inquiry saying, hey, I'm an LGBTQ guy, you need to make a website for me, turns out not to have wanted that website. It's not clear who sent the original demand, whether it was sent in his name. But in any event, apparently in good faith, the demand was made. The case went forward. It moved its way through the courts. It reached the Supreme Court. So now the New Republic is basically somehow implying that the outcome is invalid because the case is sort of bogus, because there's no real plaintiff, because there's no genuine conflict. There was no real LGBTQ person who wanted the website. And so the idea here is the Supreme Court is being horribly irresponsible and activist by taking a fictitious case that's not based upon genuine defendants. They're not really in these problems. And so this is a sort of a hypothetical that the court has taken up, and yet it's making a ruling that's going to affect so many other situations. In other words, by and large, this is a big win for religious liberty, and it's a big blow for the agenda of the LGBTQ activist movement. A bunch of senators, Senator Sheldon Whitehouse, faux litigation takes a new step into fakery in a Supreme Court case. And the point I want to make about all this is that while the New Republic thinks it's onto something really big, the simple truth of it is a lot of prominent cases going back really over the last 50 years, cases that you and I know by name, major cases, are also bogus in this sense. And by bogus in the sense, what I mean is, consider the case of Rosa Parks. Was Rosa Parks a tired old woman who just got into the bus and then didn't want to move to the back of the bus? No, she was an activist. She worked for the NAACP. They put her up to it. She had trained for this. This was, in other words, a staged event. And so the great Rosa Parks case was propagandistically presented as a tired old woman, but that's really not what it was. Similarly, the NAACP followed a very conscious strategy of creating cases involving segregation, and ultimately in the Brown case, Brown versus Board of Education, challenging segregation itself. In a prominent case in the 1960s, Loving versus Virginia, that involved interracial marriage. there was a challenge to an old law in Virginia that prohibited interracial marriage. Well, Virginia wasn't prosecuting people who were interracial and who got married. The law was archaic. It was just there on the books. But nevertheless, the left wanted to knock it out. And so they produced an interracial couple and they produced a challenge under the law, even though, again, the law wasn't actually being carried out. The sodomy case as well. There were old laws against sodomy. It wasn't that they were being enforced. Even in the contraception case, Griswold versus Connecticut, it's almost like the left stages the event. They force an arrest. Look, we're actually deliberately breaking the law. We want you to arrest us so we can file a case. And so all these cases have gone, as you can see, Rosa Parks, the Brown case, Loving, the sodomy case, Griswold, all go before the court, but they're not real conflicts. It's not as if Rosa Parks really had a problem sitting in the bus. She was put up to it. Similar, so what I'm getting at is that while the left thinks that in this particular case they've got a big winner, oh listen, we can't find a real plaintiff, and so on, ADF's point is that it's irrelevant. The woman got a request, she made a complaint, and she basically said that, look, I don't want to be found in violation of the law because I refuse to make a website. That issue carried itself forward before the court, and the court made a ruling. So it's not a, quote, hypothetical case. It's a real case involving real principles, and the left is only angry it didn't come out their way.